Hello and welcome to Unacademy, a one-stop destination for the English medium civil services aspirants. Indian Express newspaper needs no introduction. For the past many years, consistently, a substantial number of questions that have been asked in the prelims examination, their source can be traced to the Indian Express, and more importantly, more specifically, the explained page of Indian Express. In our endeavor to provide exam-oriented content to the civil services aspirants, we have come up with yet another initiative. Every week, we will come up with a summary of the important explained articles of the Indian Express across subjects, polity, international relations, economy, environment. That is going to be extremely fruitful for your upcoming prelims examination. What are your thoughts on this new initiative? Do let me know in the comment section. And before we start, yet another important announcement. The Honorable Finance Minister yesterday, in her budget speech, gave some bonanza to the middle class, some tax rebates, and there is a bonanza from Unacademy to the civil services aspirants as well. You can get access to the paid course of Unacademy, the plus course of Unacademy, without paying any fee for the next 7 days. All you have to do is enroll before February 3. And if you do, you will get access to all the online courses and batches. More importantly, I am teaching polity in the morning in the Ignite batch from 6 to 9:30 a.m. And I'm in the middle of fundamental rights discussion. Should you wish to attend the polity for the next 7 days, I would be delighted if you can join me. And we are going to start Article 16 of the Constitution tomorrow, Monday, 6 a.m. in the morning. So please join me and let's get started and let's discuss 5 important articles from Indian Express explained page, relevant for polity, relevant for the upcoming prelims examination 2025. Topic number 1. Why Delhi High Court allowed a 60-year-old couple to access dead son's sperm. A 30-year-old man was suffering from cancer. And once you're suffering from cancer, you also are subjected to chemotherapy. Chemotherapy, it has an impact on the motility, the health of sperm, the count of the sperm. And it's a common practice throughout the world that if you are opting for chemotherapy, before that, what you do, you get your sperm cryopreserved at a hospital. Basically, you freeze the semen. And later on, it can be used for surrogacy purposes. It can be used for IVF. This person unfortunately died. After his death, the parents approached the hospital asking for the release of this frozen semen. And the hospital refused. Matter went to the court, and the court ruled in favor of the father and mother of this deceased man. This is where it becomes important for your exam. For that, we need to understand what is Assisted Reproductive Technology Act of 2021. This is the law which regulates and supervises all the fertility and artificial insemination procedures in India. And you would know, to implement a law, we need rules as well. And these rules were made in 2022. And these rules, they talk about posthumous retrieval of sperm, which means after the death of an individual, you can retrieve the sperm, which should ideally be done within 12 to 36 hours of the death. But the rules say, who can ask for the retrieval of the sperm after the death? This can be asked by the surviving partner of this person, which means this person has to be married. But this 30-year-old man, he was not married. And who was asking for the retrieval or the release of that frozen semen? Not the surviving partner, but the parents of the man. The parents, they came before the court that we are ready to support this newborn child or to support the upcoming child. We, along with our daughter, we are going to support that newborn. And we will have to ensure that we are providing the best possible support. For that, we require this frozen semen so that we can opt for surrogacy, so that a child is born and we are there to take care of that child and we want to continue our lineage. The central government was asked, what is your take on this matter? The Ministry of Health and Family Welfare was asked to submit an affidavit. What is your take on this matter? And the ministry said that the purpose of this law, which was passed in 2021, and the rules, its purpose is not post-mortem grandparenthood. So we can discuss post-mortem parenthood if the surviving partner of this dead man is asking for the retrieval of the sperm. But this law does not talk about the possibility of after death grandparenthood. But ultimately, the family approached the court and convinced the court. And the court was convinced because of various reasons. Reason number one, the court favored the petitioners, agreed with the petitioners on the ground that this man died in 2020. The law was passed in 2021. The rules were made in 2022. And these rules do not talk about post-mortem retrieval of sperm to the parents. It talks about post-mortem retrieval of sperm only to the surviving partner if the person is married. But this law was passed in 2021, the rules were made in 2022, but the man died in 2020. This law was not given a retrospective effect. So at the time of the death of this man, this law was not in force. That means there is no prohibition on the release of the gamete to a person other than the spouse, which means we can release it to the parents as well. Second, the petitioners also claimed that this frozen semen is like the property. Just like we have the human corpse or the organs. Since they are also treated as the property of an individual, this frozen semen can also be treated as the property. And after the death of this man, since the man was not married, since the man did not have the children, since the man did not have a wife, who becomes the legal heir of this man and his property? The parents. And this is something which is mentioned under the Hindu Succession Act, where the parents are considered to be the legal heir of the deceased. There is no spouse or dependent children of the man. And that is how the court ruled in favor of the couple, the parents of the deceased man. That becomes important for your examination. Let's look at article number 2, Rohit Bal succession controversy. What are the elements of the valid will? Rohit Bal is considered to be the most prominent and renowned fashion designers in India. He is considered to be the one who designed the outfit for Kaun Banega Crorepati. He is the one who would count top clients in terms of Uma Thurman or Naomi Campbell as one of his clientele. And he was the one who was also once the brand ambassador of Omega watches. These facts are not important for your exam, but this is just to tell you the significance of this man. He was born in Kashmir, was suffering from some cardiac issues and ultimately died because of the cardiac arrest. And he was also a prominent member of the LGBTQ community. But once you are dead and once you are alive, you also submit and prepare a will. Now there is a controversy on his will. On one hand, his longtime friend, who was once his partner as well, Lalit Tehlan, he is claiming that the will prepared by Rohit Bal favors me. But the stepbrother of Rohit Bal, Mr. Rajiv Bal, is claiming otherwise, and the matter is before the court. We don't have to go too deep into the controversy regarding this family, but we need to understand what is the scope of a will, how the will is prepared, which can be important for your upcoming prelims examination. When it comes to testamentary succession, which means your assets are to be divided, distributed after your death. How the subject of succession or will is governed? It is governed by Indian Succession Act of 1925. And since you would know that there is no uniform civil code in India, which means when it comes to personal laws related to marriage, divorce, inheritance, adoption, different religious communities are governed differently according to their own religious beliefs, customs, and laws. Muslims dealt separately, Parsis dealt separately, Christians dealt separately. So under Indian Succession Act, it applies to all Hindus, Sikhs, Buddhists, and Jains. What constitutes a legal will? A person, this Indian Succession Act, it allows the maker of the will that you can revoke this will at any time. But who can make this will? Only that person who is a major, that means 18 or above, and somebody who is of sound mind can make the will. That means if you are making a will under duress, if you are making a will under threat and you have to prove it in the court of law, this will can be discarded. Who can make a will? Somebody who is of sound mind, somebody who is a major. And Indian Succession Act applies to these communities. But if you have made the will once, you can also revoke it. Provided while you are revoking this will, you should be of the sound mind. If you are revoking the will during an unsound mind period, then it won't be valid. But what if an individual makes multiple wills? Which will prevail? The will which was executed last will be valid. These are important facts, can be relevant for your examination. But there is something else as well. Rohit Bal's will must meet another condition of an unprivileged will. There is a privileged will, there is an unprivileged will. Privileged will is something which is executed or which is made by an active soldier, airman, or a mariner at sea. Because these people are dealt separately because of their unique circumstances, special circumstances where they are working. So they don't have to follow the strict procedures as are to be followed by those who are making unprivileged will. Which means what? If Rohit Bal has made this will and Rohit Bal becomes a testator, if he has made the will, he has to sign on this will. If he is unable to sign it, he has to empower somebody. He has to direct another person that you sign on my behalf. But all this should be done in presence of two witnesses. And these witnesses should also see that Rohit Bal was signing this will. Somebody who was directed by Rohit Bal was signing this will. All this has to be done, and only then this will be considered valid if it is challenged in the court of law. So for your examination, what you need to understand, without getting into the controversy between the partner, long-time friend of Rohit Bal and his stepbrother, you need to understand Indian Succession Act applies to which communities, what are the criteria under which your will can be declared as valid, and what is this unprivileged will that is being spoken of? A will made by anyone who is not an active soldier, airman, or a mariner at sea. That is an unprivileged will, because the will made by these people, that is known as a privileged will. This is what you need to understand. Let's look at third important topic, Badlapur sexual abuse. Can political parties exercise their right to protest, to call for a bandh? Now we know we have a fundamental right under Article 19, Clause 1, Clause A, which deals with freedom of speech and expression. If you have freedom of speech and expression, you can protest as well. That is also included as your fundamental right. We also have a fundamental right where we can assemble peacefully without arms. This right of assembly is also a form of protest and is guaranteed by the Constitution to all the citizens under Article 19. But you would also know that this fundamental right is not absolute. It comes under reasonable restrictions. And one such reasonable restriction is public order. Now, what happened in Badlapur? An unfortunate event where a school sweeper, he was accused of sexually molesting two 4-year-old girls. Then there was a political controversy, and MVA, Mahavikas Aghadi, announced and called for a bandh in Maharashtra, which ultimately the High Court later on, as well as the Supreme Court previously, Supreme Courts as well as High Courts, Supreme Court and High Courts, they have made a distinction between freedom to protest and the right to enforce and call for a bandh. After the Bombay High Court heard this matter, the MVA decided to recall this call for a bandh. Now, what is a bandh? That is something which becomes important for your exam. Bandh is when you call for the cessation of all kinds of activities, which means the buses will not ply on the road, the shops and establishments will not be allowed to open, which means it will affect the essential services as well. People commuting to the hospitals may also get inconvenienced. When you enforce for a bandh, this is what Kerala High Court said in 1997. When you call for a bandh, when you organize a bandh, when you enforce a bandh, then the organizers of that bandh, the workers of that political party, they will also expect all activities to come to a standstill, which means the workers of the political party will force shopkeepers not to open their shops, will force people not to use public transport, will force people not to commute because you want cessation of all kinds of activities, which will also disturb public order, and it is the state's responsibility to uphold and protect public order. Not just that, we also have the freedom of movement throughout the territory of India under Article 19. We also have a fundamental right to carry on any trade, any occupation, any profession as well under Article 19. So same article which provides you the fundamental right to freedom of speech and expression, to assemble peacefully without arms, same article also gives citizens the fundamental right to move freely throughout the territory of India, to carry on with any trade, occupation and profession as well. And there is a reasonable restriction on Article 19, which is public order. The state has the duty to protect, uphold public order. And this is where Supreme Court previously, various High Courts as well, they have consistently said that although you have the fundamental right to protest, but you don't have the right to enforce a bandh. Because when you call for bandh, you are basically asking for cessation of all kinds of activities, which will cause inconvenience to the public, which will affect other fundamental rights of the public, including their right to life with dignity under Article 21 of the Constitution. So does Article 19 include a right to call for a bandh? The simple answer is no. And this is exactly what Supreme Court also said when there were protests against the Citizenship Amendment Act in Delhi, particularly at Shaheen Bagh, where the protesters, predominantly Muslim women, they had blocked an important road in Delhi. The Supreme Court said, you have the right to protest. You have the right to peacefully protest against a legislation. But we have to be categorically clear that you cannot occupy public places, that too indefinitely, for an indefinite period of time, because you are causing inconvenience to others. That is why Supreme Court in the Shaheen Bagh case said, protests can be conducted at designated places. Without causing inconvenience to others, without blocking an important road, without affecting the fundamental rights of others. So you can have a designated place where people can protest without causing inconvenience to anybody, because right to enforce a bandh is not a right, and cessation of all kinds of activities is not a right. That is what you need to understand from this article. Let's look at topic number 4. Why Karnataka High Court upheld governor's nod to investigate Chief Minister Siddaramaiah in alleged Mudda scam case. Please understand, There is Section 17 capital A of the Prevention of the Corruption Act. This was not originally part of this act. This was inserted into this act in 2018. What is the purpose? For example, there is a public servant, and public servant is discharging his duty. Public servant is discharging his duty in his official capacity. For example, issuing a old age pension to somebody, to a beneficiary, or providing some, let's say, property under Awas Yojana, a Pakka house to somebody who is a beneficiary. What if you allege corruption in this case? What if you allege corruption by this public servant? There can be large number of frivolous cases that people can file against this public official, which means that these public officials would be scared of taking any decision, carrying on with their official duties, because they will fear the law, they will fear the police, they will fear the cases. That is why a protection was provided to these public servants by Section 17 capital A of the Prevention of the Corruption Act, under which police, before it can investigate this public servant, it has to seek approval of the competent authority. Now, which is that competent authority? If you are working as a state government employee, the permission should be given to the police by the state government. If you are working in the central government office, the permission to the police should be given by the central government. Or the permission should be given by that entity which is capable of removing you from your office. Which means this section is meant to protect public servant. Otherwise, tomorrow when you become IAS officers, you will be hesitant in taking any decision, because no matter what decision you will take, the police may order the investigation and start carrying out investigation in this particular case. Now, to protect you, the concerned state government or the central government or the person who is capable of removing you should give permission to the police. Without that permission, no investigation can take place against you. Now, what happens in this case? Mysuru Urban Development Authority, it illegally acquired some land in Mysuru for the redevelopment of Mysuru, illegally. And when this land was illegally occupied, then Mudda came up with a scheme that we will compensate those owners whose land we have illegally acquired. And how will we compensate? We will provide them plots in Mysuru because we have illegally occupied their land. One such beneficiary was the wife of the Chief Minister, Siddaramaiah. And this property, this land, which was illegally occupied by Mudda, this belonged to the wife of the Chief Minister, but the wife of the Chief Minister bought it from her brother. That means the owner originally was the brother-in-law of the Chief Minister. And this brother-in-law had acquired this property from a Dalit. But that's a different story altogether. We don't have to go too deep into the nitty-gritty of this case. But what we need to understand is that the wife of the Chief Minister bought this property from the brother, which means the Chief Minister's brother-in-law. And this land was illegally occupied and acquired by Mudda. Now, to compensate the landowner, residential plots were provided to the Chief Minister's wife. And this is where there was an allegation of corruption. Now, 3 anti-corruption activists approached the governor that you should give us the nod, you should give us the approval so that the Lokayukta, the police, can start investigating the Chief Minister. Now, why the governor's sanction was required? Because under Section 17A of the Prevention of the Corruption Act, Chief Minister is the public servant. And while he is discharging his duty, if there is an element of corruption, then who has to give you permission? Who has to give police the permission to carry on the investigation? either the state government, if you are under state government, or the central government, if you're working under the central government, or the person who is capable of removing you. Who appoints the chief minister? Governor. Who has the power to remove the chief minister? Governor. That is why these three anti-corruption activists approached the governor, please give us your permission so that Lokayukta, the police, can start investigating the chief minister. Because without prior approval of this competent authority, no investigation can take place. And Mr. Siddaramaiah approached the Karnataka High Court against this sanction given by the governor. And primarily on three grounds. Ground number one, whether sanction can be given when the complaint is made by a private person. Because I told you section 17 capital A specifically talks about police has to take the sanction of the competent authority before it can start investigation. But here the police is not approaching the governor. Three private persons are approaching the governor, asking governor's sanction so that the police can start investigation. Mr. Siddaramaiah approached the Karnataka High Court and said, this sanction should not have been given because police is not asking for the sanction. It is the three anti-corruption activists, three private persons asking for the prior approval. Second, Mr. Siddaramaiah says, I was not the decision maker because when this property was illegally acquired by Mudda, or when these residential plots were given to my wife, I was not holding any post. I was not the chief minister. So I was not a public servant discharging my duties. So I should not be held accountable in this case. And third, we need to understand that there shall be a council of ministers headed by the chief minister to aid and advise the governor, who shall act on that advice. Which means whatever advice is given by the chief minister and council of ministers is binding on the governor. The cabinet met, advised the governor that you should not give sanction to the police. You should not give sanction to Lokayukta. Even against that advice, the governor is giving the sanction. Mr. Chief Minister argued before the Karnataka High Court that governor could not ignore the advice of the Council of Ministers. Because under Article 163, you have to act on the aid and advice of the Chief Minister and Council of Ministers. On all these three grounds, the High Court disagreed, and that is how this matter is now being probed and investigated by Lokayukta. Now, on matter number one, the court said, if private person cannot approach the governor asking for prior sanction, then what is the alternative available with this private person? Listen to me carefully, very important point. Then this private person has to approach the police under Bharatiya Nagarik Suraksha Sanhita, BNSS, or previously Criminal Procedure Code. And then police has to necessarily file an FIR and carry on the investigation. That means a provision which was meant to protect the public servant from frivolous cases, from illogical cases. This provision would be left redundant. That is why not only police, even private persons, if they have an allegation of corruption against a public servant, they have to approach the competent authority. Without the approval of the competent authority, no investigation can take place. Number one. Number two, the court said, look at the facts of this case. When this land was acquired or bought by the brother-in-law of the chief minister and then gifted to his wife, to the wife of the chief minister, at that time it was an agricultural land. And this agricultural land was then converted into a residential land, and at that time, Mr. Siddaramaiah, you were a member of the ruling political party. Then when the scheme was launched to compensate those whose land has been illegally acquired by Mudda, and we will compensate them by giving them residential plots. And this scheme, this compensation was enhanced. At that time, your son, he was the ex officio member of Mudda. Mysuru Urban Development Authority. And when these flats or these property or this land was given, these residential plots were given to the chief minister's wife, at that time you were the chief minister. So the facts of this case is that you were consistently a member of the ruling political party, then you were a deputy chief minister, then your son was the ex officio member, which means this case merits investigation. If such a case does not merit investigation, we fail to understand what kind of case will merit investigation. That is why we are not saying you are guilty or innocent, but this case does merit investigation, and let the police investigate, let the Lokayukta investigate. And on this third issue, we disagree with you, Chief Minister, because there is a conflict of interest. The ministers have passed a resolution, has passed an advice to the governor that you should not give approval sanction to the police. But you are a minister because your name has been recommended as a minister by the chief minister. So ministers basically hold office during the pleasure of the governor, which basically means the pleasure of the chief minister. So it is unfathomable to understand that the ministers will do something which is against you. It is unfathomable to even comprehend that ministers will advise the governor to do something which goes against you. That is why we don't agree with all these 3 points. Karnataka High Court has given nod to the Lokayukta, and now investigation is taking place against the chief minister. That's what you need to understand from this topic. Why Karnataka High Court upheld governor's nod to investigate Siddaramaiah in alleged Mudda scam case. Now let's look at the last article. And the last article deals with a 9-judge bench decision verdict of the Supreme Court, where Supreme Court said by the majority of 8:1. There were 8 judges who agreed. There was 1 judge who dissented. Justice Nagaratna dissented. And Supreme Court said that states have the power to make laws on industrial alcohol. Why this case is very important? This case is considered to be a landmark case in the history of fiscal federalism in India. Constitution talks about liquor, intoxicating liquor, industrial alcohol, for example, different types of liquors. Matter went to the court in Synthetics and Chemicals Limited versus State of Uttar Pradesh 1990. The Supreme Court said states do not have the power to tax industrial alcohol. The states only have the power to tax intoxicating liquor, which means potable alcohol. Therefore, the states do not have the power to tax industrial alcohol, which means who has the power to tax industrial alcohol? That power is with the center. But what is this industrial alcohol? It's basically impure alcohol. For example, ethanol, when it is mixed with with gasoline, pyridine, then it becomes industrial alcohol. And this industrial alcohol is used in pharmaceutical industry, in perfumes, so on and so forth. But sometimes this industrial alcohol is also used to manufacture what is called as illicit liquor. And we have seen a large number of deaths in different parts of the country because of the consumption of this illicit liquor. Because when you are adding chemicals to ethanol, it becomes unfit for human consumption, which means the price reduces. But then this industrial alcohol is then used to make illicit liquor, which is then consumed by some people, and unfortunately they also lose their lives. But why did Supreme Court come to this conclusion that states have the power to tax not just intoxicating liquor, not just potable alcohol, but also industrial alcohol? Supreme Court said, look at entry 8 of state list, which talks about intoxicating liquor. If this item is given to the state list, that means this entry gives power to the state to regulate everything from the stage of sourcing raw materials, till the consumption of this intoxicating liquor, all these stages, the power to regulate is given to the states. Supreme Court further said that all the entries in the 7th schedule must be given wide meaning, which means even if there is a matter which is incidental to this matter mentioned in the state list, we must assume that it is related to the state's power. If there are conflicting views upon a particular matter, we have to side with that view which goes and which upholds the federal principle. For example, the Chief Justice of India said, what is known as liquor or alcoholic liquor, it covers intoxicating liquor if it produces the effect of intoxication. That means even the liquor, which traditionally is not considered alcoholic liquor, it can be covered in this phrase, intoxicating liquor, if it produces the effect of intoxication, which means what? Industrial alcohol can also be used to make illicit liquor, which means this industrial alcohol can be used to make illicit liquor, which is used for human consumption and to intoxicate the people, which means it comes under state list. Not just that, listen to me carefully. Intoxication is one, and then there is something called inebriation. Tipsiness, for example, you are in an inebriated state. Intoxication can also mean poisoning, because if you consume this industrial alcohol or the illicit liquor which is produced due to industrial alcohol, it might lead to poisoning and it might affect the health of the people. And health is what? State subject. It is under state list. Hence, whether it is intoxicating liquor or it is industrial alcohol, both are the domain of the state. So states have the power to tax not just potable alcohol but also industrial alcohol. And this is considered to be a judgment which will raise the revenue generating capacity and capability of the states. Because excise duty on liquor is considered to be one of the most important sources of revenue for the states. That is why, if you know, for a long time since 2017, there was a demand that alcohol and petroleum should also be bought under GST. But the states fear that they will lose revenue if this is brought under GST. And that is why this judgment is considered to be a further important judgment which can deepen fiscal federalism in India. These are the 5 topics that I wish to discuss today from Indian Express Explained page. Every week we will come up with a video where we will discuss important Indian Express Explained articles relevant for the upcoming Prelims 2025. If this session has been of some help to you, do let me know in the comment section. Do subscribe to our channel if you haven't yet, and share the links of these sessions with your friends and fellow aspirants. Thank you for watching. Goodbye.